All right. Well, I'd like to welcome everyone to the first in a series of regular arbitration briefings, which will take place during the course of this year, which we all hope that you'll find instructive. Good morning to everyone in Europe who's listening. Good afternoon to the many people joining us from Mauritius, unsurprisingly, and from the UAE. And good evening to those of you in Singapore, Australia, and elsewhere in the Asia-Pacific region. I'm Stuart Isaacs. With me are my colleagues Gourgey QC and Elizabeth Houghton, who form part of the arbitration team at Wilberforce Chambers. And today we're going to be discussing the forthcoming Privy Council hearing in State Trading Corporation and Betamax, which is scheduled to take place at the end of next week on an appeal from the Supreme Court of Mauritius. It's perhaps unusual to be holding a briefing on a case which has yet to be decided, rather than on a judgment which has already been given. But in view of the importance of the issues raised by the case for the international arbitration community as a whole, we considered that a discussion at this stage of some of those issues and an exchange of those ideas would be helpful and potentially lay the foundation for a critique of the Privy Council's judgment once it's rendered, probably later this year. I want to emphasize that we're very keen that there should be an exchange of views during the course of this briefing. We welcome your contributions, so please use the Q&A button at the bottom of your screens rather than the chat button to ask questions throughout the session. We're all happy to try and answer questions as they come along and deal with them, so please don't feel the need to wait until the end of the discussion. I'm going to begin by providing a short summary of the facts of the case, and then we'll go on to identify and discuss some of the key issues that arise. Let me say at the outset, just to whet your appetite, that at the end of this session, we're going to be holding a poll of what you individually think that the Privy Council is going to decide on this case. So just bear that in mind as we go along. So dealing briefly with the facts of the case, they're quite straightforward, but there's a very strong political undertone. Betamax is part of a substantial group of Mauritius companies. STC is a trading arm of the government of Mauritius, set up by statute and entrusted with the responsibility for importing essential commodities such as petroleum products and LPG for use and trade in Mauritius. In November 2009, the parties entered into a 15-year contract of affreightment, COA, under which Betamax agreed to transport all of Mauritius's petroleum products from a refinery in India on a vessel specially designed for that purpose. At the time that the COA was concluded, the then coalition government of Mauritius at all times maintained the legality and promoted the economic benefits of the COA. But following a general election in Mauritius in 2014, there was a change of government, and the new government included a party which during the election campaign for the first time claimed that the COA had been entered into in breach of the Public Procurement Act 2008, the domestic Mauritius public procurement legislation. And the new government undertook, if it was elected, to terminate the COA. And indeed, the new government was elected, and State Trading Corporation soon made it very clear that it didn't intend to continue to perform the COA, and indeed failed and refused to perform it further. Betamax accordingly gave notice of termination, whereby it accepted STC's repudiation of the contract and its failure and refusal to perform as bringing the COA to an end. Betamax then started arbitration proceedings, claiming damages of around $150 million US. The arbitration was conducted under the rules of the Singapore International Arbitration Centre, but importantly, the governing law of the COA was Mauritius law, and the seat of the arbitration was Port Louis in Mauritius. And Mauritius's own recently introduced International Arbitration Act implements the model law. Before the sole arbitrator, Michael Pryles, the claim succeeded, but the Supreme Court in Mauritius set aside his award on the ground that it was in conflict with the public policy of Mauritius as reflected in the Public Procurement Act.
I think to inform the discussion we're going to have in the next hour, it's helpful to at least have an outline of the decision that the Supreme Court made. There were 3 grounds of appeal before the court. Underlying 2 of the grounds was the central contention of STC that the arbitrator had erred in law in deciding that there was no breach of the Public Procurement Act, the PPA. What the arbitrator decided was that by reason of the operation of some regulations called the Public Procurement Regulations, STC was an exempt organisation. That had the consequence, the arbitrator found, that the contracts with STC were exempt from the need to comply with the procurement and approval process required under the PPA. That approval process included the requirement that any contract over a certain size and falling into certain categories, of which this would be one, required the approval of the Central Procurement Board, a requirement which was not satisfied in this case because the view that was taken at the time by all concerned, as I understand it, was that this contract was exempt from that legislation. So the 3 grounds that were advanced by STC before the Supreme Court were firstly non-arbitrability, second, invalid arbitration agreement, and third, enforcement of the award was contrary to public policy. Now, the Supreme Court, whilst of course recording the first and second of those grounds, non-arbitrability and invalid arbitration agreement, didn't actually decide those grounds. It allowed the appeal on ground 3, public policy. Before I outline briefly the reasoning on the public policy ground, let me just quickly deal with the other 2 grounds. The first ground, non-arbitrability, the argument was that the dispute before the tribunal was not one that was capable of resolution by arbitration. STC argued that this was on the footing that the dispute as to whether the COA, the contract of effraitment, was illegal, raised questions of public policy which could only be determined by the courts. Now, that argument proceeds on a very narrow definition of the concept of arbitrability. If STC was correct, it would have a severely detrimental impact on the ability to arbitrate disputes in which one party raises the defense of illegality, leading to many cases where the jurisdiction of the arbitral tribunal is ousted, contrary to the intention of the parties that all disputes be decided by arbitration. Such a narrow definition runs contrary to the norms in international arbitration practice and cannot be supported. And insofar as the Supreme Court decided through silence not to accept the ground, it was correct. The second ground was invalid arbitration agreement. And the argument here was that since the arbitration clause forms part of the COA, which was illegal, the arbitration agreement itself is invalid. That argument, in my view, was bad in law. The International Arbitration Act of Mauritius, based on the model law, expressly recognizes the well-established principle of separability that an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract, with the consequence that it's not invalid even if the contract of which it forms part is null and void. I think we're all familiar with the statement of principle of separability and the seminal decision of the House of Lords in Fiona Trust. Quite clearly, this was, in my view, a bad argument. And again, insofar as the Supreme Court decided to avoid accepting that ground, it was right. So that brings me to really the third ground, which is going to be the focus of our discussions today. The Supreme Court's analysis proceeded along the following lines. Firstly, it took upon itself the decision as to whether the STC was exempt from application of the PPA, the very question considered by the arbitrator, which he had determined in favour of Betamax. The court reached the contrary conclusion that the STC was not exempt. Moving on from there, that conclusion necessarily led to the dual findings. First of all, that the COA was a contract that was subject to the requirements of the PPA. And secondly, that those requirements were not complied with, not least because the approval of the Central Procurement Board had not been obtained. Having reached that stage, the court then went on to consider whether it would be contrary to public policy of Mauritius to recognise or enforce the COA in circumstances where the PPA had not been complied with. It reached the view that it would be contrary to public policy. We'll be discussing, as I say, in some detail, this aspect of the court's judgment, but in broad outline, the reasoning was as follows. First of all, the relevant section of the International Arbitration Act was section 39, which provides that an arbitral tribunal may be set aside only in specified circumstances, one of which is where, quotes, the award is in conflict with the public policy of Mauritius, close quotes. This wording follows the amended model law, and the court held it was the public policy of Mauritius that needed to be considered rather than some overarching cross-border international public policy. Notwithstanding that, the court appeared to accept the trend in many leading overseas jurisdictions to treat narrowly the public policy exception to enforcement of arbitral awards. It also appeared to accept that it should generally be limited to cases of clear violations of mandatory legal rules which are fundamental to the legal order of the state. Having got that far, the court then viewed the PPA as reflecting the public policy of Mauritius in prescribing and ensuring high standards of integrity, free and open competition, and protection from fraudulent and corrupt practices in the award of major public contracts to secure the efficient use of public funds. It then said that as such, the application of the PPA was, quotes, a fundamental pillar of good governance in Mauritius, close quotes. And the court then determined, having got that far, that the enforcement of a contract of the magnitude of the COA was in flagrant and concrete breach of the public procurement, would violate the fundamental legal order of Mauritius, and that the violation broke through the ceiling of the high threshold, which the court appeared to accept, may be imposed by any restrictive notion of public policy. And on that basis, the appeal was allowed. The Supreme Court's decision, which I understand from Stuart came as a surprise to all concerned, has attracted a range of views. Some commentators have been strongly supportive, others have been highly critical. What the Privy Council decides may be influenced by the highly sensitive nature in Mauritius of the Supreme Court's decision.
Thanks, Alan. I mean, it's a very interesting decision, and there are a number of topics that we'd like to cover today, 5 in fact. The first one is to discuss the Supreme Court's power the Mauritian Supreme Court's power to reopen the arbitrator's decision on the merits. The second is the effect of the finding that there had been a breach of the procurement rules. Did that automatically lead, as the court assumed, to a finding that the contract of affreightment was illegal and unenforceable? Thirdly, we're going to discuss what is the relevant public policy in the public policy exception and the approach that the court took to that question. Fourth, we're going to talk about the test that was applied by the Supreme Court on the public policy exception and whether that was correct. And finally, we want to discuss what view the Privy Council might take of this appeal when it's heard next week. So I think Alan's going to start us off discussing the court's power to reopen the arbitrator's decision on the merits.
Thanks, Liz. So the tribunal's decision was made on the merits, and there's an important question of principle, namely whether the Mauritian court, as the supervising court, could not or should not have reopened the decision of the arbitrator. it's interesting when you read the judgment to see that the Supreme Court did not consider, or at least doesn't appear that it considered, whether it had power to review the decision on the merits. It just appeared to assume that it had the power to do so. And on that basis, it carried out a de novo review of the question of whether the COA was exempt from the provisions of the Act, the very issue which had been determined by the arbitrator in favour of Betamax. De novo, because it went back to exactly the arguments that I would imagine were in front of the arbitrator, decided whether or not, in fact, there was a breach of the Act, and then concluded, then referred to the arbitrator's reasoning and said it was wrong. It wasn't as if it was an appeal against the arbitrator's ruling where the arbitrator's decisions were the subject of the focus of the decision. So this raises the question of whether the Supreme Court had the power to decide the very issue that had been determined by the arbitrator. It seems to me that there's strong arguments in favour of the view that the power of the Supreme Court as the supervisory court to set aside an award under the public policy exception does not extend to revisiting, let alone making de novo findings of fact of law of matters that were decided by the tribunal. A number of points really support that view. First of all, there's the structure of the Act. The International Arbitration Act, as Stuart has noted, follows the model law, and that enshrines the principle of non-intervention, namely that courts are not to intervene in international arbitrations governed by the Act, save in specified circumstances. Likewise, it enshrines the principle of finality, that an award is final and binding, subject to very limited and exhaustive rights of challenge. We're all familiar with those principles. The IAA adopted those principles because to do otherwise and allow extensive intervention by the courts would severely undermine the policy of promoting Mauritius as an attractive seat for international arbitrations. Against that backdrop, it could be argued that consistent with that policy and consistent with the approaches of other jurisdictions with similar arbitration provisions, the public policy exception allowing an award to be set aside must be viewed narrowly so as not to encroach on those principles. Put another way, there's an obvious tension between, on the one hand, limiting the court's intervention on the challenge of awards, respecting the principle of finality, and on the other, giving the court free rein to decide whether an award breaches public policy. The tension is obvious where in cases such as this, the very question of illegality, which underpins the public policy argument, has been argued in the arbitration and determined by the tribunal. The position under English law, which was in passing considered by reference to some old authority in the Supreme Court decision, I say in passing because it wasn't on this central issue, which the court didn't consider. That position was recently explained in the Court of Appeal decision in Sinocor in 2018, which itself followed the majority of the Court of Appeal in Westacre Investments, a 1999 decision. In Sinocor, Lord Justice Hamblin, who gave the only judgment, laid down the following principle, quotes, where the arbitration tribunal has jurisdiction to determine the relevant issue of illegality and has determined that there was no illegality on the facts, the English court should not allow the facts to be reopened, save possibly in exceptional circumstances, and one such circumstances may be fresh evidence. On at least one reading of the Singapore Court of Appeal in 2011 in Aju v AGT, which was a decision referred to by the Supreme Court in Mauritius, they approved the majority of the Court of Appeal in Westacre, which rejected the argument that the public policy exception would allow a court to revisit the tribunal's reasoning, noting that the Westacre approach is consonant with the legislative purpose of the Arbitration Act of giving primacy to the autonomy of arbitral tribunals and upholding the finality of arbitral awards. So consistent with these authorities, it could be said that the Supreme Court should have asked itself whether, as the supervisory court, it was open to it to decide afresh issues of fact and law determined by the tribunal for the purposes of its award, and that it should have answered the question in the negative. To do otherwise contravened the principle of finality and was impermissible.
Alan, I'm just going to jump in there because we've got a question which I think now might be a good time to pose it. It's from Bilshan Nurmisulu, and I'm going to make it live so that everyone can see it. The question is, in your experience, is there already some uniformity in the approach that the courts in model law jurisdictions adopt to determine the standard of review of arbitral awards?
Well, perhaps I can go first on that. I'm very pleased to see that Bilshan Nursimulu has asked a question. He was actually my junior in the arbitration and in the Supreme Court in Mauritius. I'm very pleased to have him participating. The answer to the question is that jurisdictions generally do strive for uniformity, but the theory often gives way to practical considerations, with the result that it cannot be said that there is universally a standard approach to the consistency of how you go about reviews in arbitration awards. I think Alan will probably share that view.
Well, you're right, I do share that view. I mean, one sort of departure from that perhaps I can comment on is that the public policy exception, which we will come to shortly, which of course features not only in model law, but also under the New York Convention. And I have certainly come across cases where it has been argued that in some jurisdictions, the one that comes to mind is Russia, that the public policy exception is the application of that public policy exception is not consistent with approaches in other jurisdictions. So you give lip service. This was the argument. I'm not saying it's right because I was on the other side of this argument in this case, but the argument is that the jurisdiction gives lip service to the wording of public policy of the state, but gives it a very broad application on the facts. So I think the lack of clarity of definitions such as public policy, understandable lack of clarity, does give rise to a difference of approach between jurisdictions on its application. Let me just, having discussed the question of whether or not the arguments in favour of saying that the Supreme Court should not have revisited the decision of the arbitrator, look at the questions from the other side of the coin. And I think there is an argument that could be advanced to support the view that the Supreme Court was entitled to decide the question afresh. And I think I tentatively suggest that building blocks for this argument would be as follows. First of all, Section 39 provides an exhaustive list of when the award can be set aside. One of those is public policy of the state. There's no qualification in the section of this exception. The consequence, it could be argued, should be that the court must be entitled to determine the content of public policy and whether enforcement of the award will breach it. Otherwise, you are ousting from the court's jurisdiction the ability to determine a very important question as to the public policy of the state. And so if the tribunal has misstated the law and as a consequence misunderstood public policy, the court should have the ability to revisit the decision rather than be bound by what is a false statement of the law. And as regards the authorities that have been I've referred to, one view of those authorities, it seems to me, may be that when the court said you should not be revisiting the decision of the tribunal, that was concerned with questions of fact, but not with questions of law. So if the tribunal has misstated the law, and as a result of that, misstated the public policy, it should be open to the courts to review that as part of their supervisory jurisdiction and come to a different view. So that I suggest is at least one basis of countering the arguments of the appellant. I don't know whether you want to now pass on to the second issue. I think you're on mute, Liz.
Thank you. Sorry about that. The second question is, even if the Supreme Court was correct in finding that the procurement rules were not complied with, does it necessarily follow either that the contract was illegal or that the enforcement was contrary to public policy? So I'm going to talk about the illegality issue first. And this is a really interesting question, because it's what was the effect and what should have been the effect of finding that there had been a breach of the procurement rules? And did that automatically lead, as the court assumed but didn't analyse, to a finding that the contract was illegal and unenforceable? The court said that once the contract was found to be in breach of the procurement rules, it merely stated that it was illegal. But that conclusion, in my view, doesn't necessarily follow, because there was no analysis undertaken by the court as to the status of the contract. So the procurement rules themselves, which I've reviewed, do not contain any provision which deems a contract made in breach of those rules to be either illegal, unenforceable, or void, or anything like that. And we can compare that with English rules, and I understand there are Mauritian rules as well, which have the same effect, which deem certain contracts to be void when they're made in breach of certain legislation. So an English example is the English Competition Act, which expressly states that agreements which are prohibited by that act are void. But the procurement rules that we're dealing with do not provide that any such contract would be void. They do say that a person who solicits a contract in breach of the procurement rules commits a criminal offence, but the legislation is silent as to the effect on a contract. And so what we have then is a question of interpretation of the legislation as to whether or not a contract made in breach of it is unenforceable. Another really interesting aspect of this part of the decision and the lack of discussion by the Supreme Court is there was no analysis of the interaction between the circumstances in which a contract which is unenforceable might be said to be in breach of public policy, and the doctrine of illegality, which sets out the circumstances in which a contract will not be enforceable as a matter of domestic law because it's illegal. And I understand that there is some similarity in the applicable rules in England and those in Mauritius. In England, there's recently been a flurry in the last 4 years or so of Supreme Court cases on the doctrine of illegality and the unenforceability of a contract for illegality. And I won't go into those. I understand in Mauritius, a contract will only be void for illegality under the civil code where the contract has been entered into for some unlawful purpose. So in my view, there's a very interesting question between those illegality principles, the English principles and the principles that apply in Mauritius as well, and the basis on which a claim might, on the one hand, be denied on illegality principles, and a comparison, on the other hand, between the public policy grounds for refusing to recognise an award because a contract is said to be illegal and contrary to public policy. So the test in England at the moment, at least, for illegality is there's a trio of considerations that are said one needs to consider. The first is you identify the underlying purpose of the illegal conduct and whether that purpose would be enhanced by denying a claim. Then you look at other public policy considerations, and then thirdly, you look at whether denying the claim would be proportionate to the illegality. one might well substitute award for claim in that test and come to a conclusion on illegality in the context of the public policy exception. But there was no analysis of the interrelationship between those principles and the principles that apply in Mauritius by the Supreme Court. And one might well think, as I've said, that there should be some harmony between the two. On the one hand, the principles on which a court would refuse a claim in its own jurisdiction on the basis of illegality, and second, the principles relevant to the recognition of an arbitral award. I mean, in my view, if those principles had been considered, it's probably likely that the court would have nonetheless concluded that the contract was void, illegal, or unenforceable, and any claim based on it would have been denied. But the interesting factor is that the point was not dealt with at all. And it becomes even more interesting if you consider the situation where you might have a contract which is in technical breach of procurement rules. For example, the procurement process has been followed, the contract's been approved, but a formal sign-off which is required under legislation might have been overlooked. Would such a contract also be illegal and contrary to public policy? I think on the basis of the Supreme Court judgment, it might have been, because although the court said that you need to have a clear and flagrant breach in order for an award to be set aside, it didn't analyse in any great detail whether or not the breach that it was concerned with met that criteria. So that's the second point. And the third point, which I now want to come into, is we're talking about the public policy exception. It's obviously very important to identify what the relevant public policy that we're talking about. And in the Supreme Court, Betamax stressed that the focus was on, should be on, the international public policy of Mauritius. STC said that it was the domestic public policy of Mauritius which was relevant. The Supreme Court appeared to recognise that distinction, and I think the Mauritian case of Cruise City had recognised that there was a distinction to be made between those two aspects of public policy. But it's unclear to me, and I don't know if Stuart and Alan have a view on this, whether or not, after stating the distinction between domestic public policy of Mauritius and the international public policy of Mauritius, it's unclear to me whether the court expressly stated which of those it was applying. I don't know if you have a view, Stuart.
Well, I share your view. It seems to me that the Supreme Court recognized the need to apply international public policy, but in the application of international public policy, it seems to have fallen back on what in reality is domestic public policy of Mauritius. And I think this is one of the weaker areas of a judgment which as a whole is not the strongest of judgments generally. I'm not sure whether the Supreme Court really thought it was applying international public policy, or on the other hand paid lip service to it and under the guise of international public policy in fact applied domestic public policy. There's a big debate there.
Yeah.
I beg to disagree on that, if I may, Stuart. I think that if you look at the judgment of the Supreme Court, it recognised that international public policy is confined to the violation of fundamental concepts of the legal order of the state concerned. It then went on to analyse the PPA and reflect on the significance of the contract, and came to the view, as I read the judgment, that test is satisfied. So it applied, or purported to apply, the international public policy test. There may be a very big question mark as to whether it was entitled to treat on the facts of this case and the nature of the breach as engaging that, as meeting that public policy test. That's another matter. And that may be why you refer to lip service, but lip service or not, the judgment, it seems to me, properly interpreted, does seek to apply that narrower international public policy test.
Well, perhaps we'll come back to this when we're looking at the application
Yeah.
of public policy, be it international or domestic.
Yeah, before we get there, I think we're talking about the difference between international public policy of Mauritius or domestic public policy of Mauritius. It's quite an easy thing to state, but it's actually quite difficult to define. So I do have some sympathy. The test, I think, if we were applying English principles, comes from the Westacre case, which I think Alan's already mentioned. And in that case, it said it's difficult to see why acts outside the field of universally condemned activities such as terrorism, drug trafficking, prostitution, paedophilia, or anything short of corruption or fraud in international commerce should invite the attention of the English public policy exceptions. That's what I understand to be international public policy from that case. I believe there's also some further guidance which we can get from the International Law Association's interim and final reports, which were published in 2000 and 2003. Stuart, I don't know if you want to say something about those.
Yeah, well, the ILA published a final report in 2003, and it recognized that international public policy is generally considered to be narrower in scope than domestic public policy. The difficulty again comes back to the definition of the contents of public policy and international public policy. The final report, if I can just quote from it very briefly, recommended this, and we'll come back to it in a moment. It said the international public policy of any state should include 1, fundamental principles pertaining to justice or morality that the state wishes to protect, even when it's not directly concerned. 2, the rules designed to serve the essential political, social, or economic interests of the state, these being known as loi de police or public policy rules. And 3, the duty of the state to respect its obligations towards other states or international organizations. And I think that actually probably brings us on to the correct approach to the public policy exception and the test that was applied by the Supreme Court. And it may be that Alan and I will have different views on this as well. But Article 34(2)(b) of the model law provides that an award may be set aside only if the court finds that the subject matter of the dispute isn't capable of settlement by arbitration under the laws of this state, or the award's in conflict with the public policy of the state. Similar provisions in Article 6 of the New York Convention, and they are reflected in Section 39 of the Mauritius International Arbitration Act. And the Supreme Court, in my view, adopted an expansive approach to the public policy exception. International jurisprudence shows that there has to be a clear violation of mandatory legal rules fundamental to the legal order of the state in question, and that the breach has to be flagrant. And indeed, that was accepted by the Supreme Court itself. I come back to the point I made earlier about lip service, with which Alan may disagree. But let me just put these bullet points, as it were. First of all, is public procurement legislation a matter of public policy in the first place? There's a lot of conflicting authority on that. It's not a foregone conclusion that it would be a matter of public policy. Was the PPA a rule designed to serve the essential political, social, or economic interests of the state? Well, I think probably the answer to that, so far as Mauritius is concerned, is yes. At the time the COA was entered into, STC and indeed the Mauritius government's own lawyers opined that the PPA was not infringed by the COA. Well, let's assume, for the purposes of argument, that that opinion was wrong. Does that then make the violation clear and the breach flagrant? In my view, the answer is no. Should a lower threshold be applied in determining whether public policy has been infringed? In my view, no. Then how do you balance competing public policy considerations? Because what we haven't discussed so far, and we don't have time to debate, is the competing public policy stressed in the International Arbitration Act's preamble itself of promoting Mauritius as an international arbitration center. And that public policy objective has certainly not been helped by the Supreme Court's decision. And I think a final question here is that should the question whether Mauritius public policy has been infringed be left to the Mauritius Supreme Court? I think the answer to that is no. The Privy Council is sitting as the apex court of Mauritius, and the Mauritius legislation gives the Privy Council a role. So I don't think it should simply be a matter of leaving it up to the Supreme Court. My own view is that the Supreme Court's analysis is flawed. First of all, because it took too broad an approach to the application of international public policy. And second, the assumed infringement of the PPA wasn't sufficiently clear or flagrant. Going back to the alternative competing public policy, even if it's assumed that the Supreme Court's decision is correct, and the Privy Council may decide that it was, it will have done Mauritius no favours, in my view, as a venue in the future for international commercial arbitration.
Well, perhaps I, again, can beg to disagree with you, Stuart, and
healthy
the other
debate.
side of the argument. I think the starting point is the view taken by the Supreme Court of the importance of the PPA. I referred to this right at the start of this webinar, and in particular, the reference to the PPA reflecting the public policy of Mauritius in prescribing and ensuring high standards of integrity, freedom from competition, free and open competition, Freudian slip, and protection from fraudulent and corrupt practices. It seems to me that it can probably be said that the Supreme Court is best placed to reach a view on the public policy of Mauritius. I hear Stuart's point that the Privy Council is sitting at the apex of the court system in relation to the International Arbitration Act, and that may mean that it's best placed to decide what is meant by particular words within the Act. But it doesn't seem to me that that argument extends to questions of the public policy of Mauritius, where, in my respectful submission, the Privy Council should be deferring to the Supreme Court, which is best placed to decide those matters. Now, whilst there may conceivably be cases where public procurement legislation may not be a matter of public policy, this is not such a case. The Supreme Court has eloquently explained the importance of the PPA to the fundamental legal order within Mauritius. And it's got to be borne in mind and should not be forgotten that, as viewed by the Supreme Court, the COA was a contract of high value relative to the size of the Mauritian economy, and was of lengthy duration. The Supreme Court noted that the contract, which is a 15-year contract in respect of the transportation of petroleum products, which the Supreme Court said is a vital commodity for Mauritius, which has to rely for the whole of its supply by way of importation from abroad, that this covered all imports from India in relation to petroleum products. It was an extremely important contract for the Mauritian economy. So one can well understand the view taken by the Supreme Court that the failure to comply with the PPA was a very serious matter, given the contract's magnitude. It's not a case where this was a contract that was for a minor commodity barely above the minimum threshold under the PPA, quite the contrary. So they were justified in taking the view that in that context, the breach was serious, and the breach was clear or flagrant, because notwithstanding the views mistakenly taken in the Supreme Court's view by others at the time of the PPA, there was a clear breach of the PPA. Mistake of law is not a defence to a public policy exception applying. So it seems to me that the Supreme Court, whilst perhaps not setting out its reasoning as clear as one might have hoped in a case of this importance, was nevertheless justified in reaching the view that the public policy exception had been engaged. Anyway, those are the arguments I think that can go the other way to Stuart's view.
All right, well then, I think we come on to the last part of this webinar, which is what view we think that the Privy Council might take. Given my own involvement in the case, I don't think I'm going to express a definitive view on that, but I'm just going to make one or two observations and then leave it to Alan and Liz, and indeed everyone participating in the poll. The Privy Council could decide the appeal on the narrow ground that the Supreme Court's construction of the relevant provisions of the PPA was wrong. That would be the easy way out if it's going to allow the appeal. Or it could take the opportunity, in view of the importance of the issue to the international arbitration world in general, to decide the appeal on the basis that it wasn't open to the Supreme Court to reopen the tribunal's decision, or that the criteria for setting aside an award on the ground of public policy were not met. When there was debate many years ago about whether it was lawful for the United Kingdom to enter into the European Economic Community, something that is now lost in history, Lord Denning, when he was Master of the Rolls, made the observation that legal theory had to give way to practical politics. And the relevance of that observation here is that there will be a significant impact on the Mauritian taxpayer if the appeal is allowed, or if the Supreme Court had upheld the arbitrator. And although it would never be expressed in those terms, it's possible that that may influence the Privy Council in deciding to uphold the Supreme Court's decision. As I said, the bottom line is that whatever the outcome of this case, the decision is not good for Mauritius's efforts to promote itself as a regional arbitration hub. Alan?
Right, you want me to go first, do you? Okay.
I don't mind.
I was going to suggest Liz went first, but okay, I'll go first. I can't comment on whether the Privy Council is likely to decide on the narrower ground that you suggested. That goes down to the construction of the legislation, and I'm not sufficiently versed in it to know whether the Supreme Court was right or whether the arbitrator was right. Assuming that that point goes against the appellants, then there's 2 points left. One, the first issue which we discussed, which was the entitlement of the Supreme Court to reverse the findings of the arbitrator on the law. It seems to me that it's quite difficult to call this, but my view is that the Supreme Court is probably more likely than not to decide that the Supreme Court was entitled to go down the route it did. I think the respondents to the appeal is going to have the obvious difficulty that the Supreme Court didn't even consider the question, which is never a very sort of happy way to start resisting an appeal. But nevertheless, it seems to me that this was a pure point of law. I can see why the English and Singapore authorities might be distinguished. And it will be very interesting to see whether the Privy Council limits the cases of Westacre and Sonicor to findings of fact, or whether it says that those principles also extend to findings of law. My guess is that it will be limited to findings of fact. And then that leaves the question of, assuming that's right, was the Supreme Court correct to decide there was a breach of public policy? I think that the weakness in the judgment in the Supreme Court, or one of the weaknesses, is the lack of reasoning, of clear reasoning, to explain how you get from the position that the PPA was an important statute, breach of which could give rise to breach of public policy. How you get from that point to the view that in this particular case, the failure to comply with the PPA was of such a nature, so flagrant and clear, that it breached it satisfies the public policy exception. And I think that there is notwithstanding what I said a few moments ago in terms of my response to Stuart, one has to acknowledge that there is a bit of a lacuna in the Supreme Court's decision on this, and that may tip the balance in favour of the appellant. So that's a rather long-winded way of saying that I think on balance, the likelihood is that the Privy Council will allow the appeal.
Yeah, I think my view is that it is finely balanced. I think the merits of the legal argument are with the appellant. I think that there will be probably a strong reluctance, though, on the part of the Privy Council to allow the appeal unless they can find a clear basis for doing so because of the consequences for the country. I think on the 2 points that Alan's made, I think the court might find that the Privy Council might find that the Supreme Court was not right to find that it could reopen the decision of the arbitrator. I mean, as we've discussed, there wasn't even any analysis of whether by the Supreme Court of whether it had the power to do so. It just seemed to assume. And then the second question, which Alan discussed, whether there was a breach of public policy. I think that's quite a difficult question, and the Privy Council, although the Supreme Court said that there was a clear and flagrant breach without much analysis, I think the court might say, well, it is a very serious piece of legislation. It was enacted for all the reasons that the Supreme Court articulated, and a breach in these circumstances, which is not a technical breach, must be a breach of public policy. So I think it's difficult, but I think on balance, it's likely that the appeal will be allowed. So we'll find out, hopefully not too distant future. I think Hayley's now going to launch a poll. It's anonymous. So if you'd like to, it's just for interest's sake, to see what your views are about whether or not the Privy Council will allow the appeal or not.
I think for the sake of clarity, for the sake of clarity, you should assume for the purpose of the poll that the legislation has been breached.
Yeah, so we're just talking about the public policy
and the ability to revisit the tribunal's decision.
Yeah, so once everyone's had a vote, we'll find out from Hayley what the results are.
I'm not going to tell you which way I'm voting.
Okay, so we've got 70% of participants believe that the appeal will be allowed. So we'll hopefully be back in a few months or so once we've got the judgment, once the hearing's been heard and we've got the judgment, to find out whether or not that was accurate and to have a look at the judgment, which will certainly be very interesting whichever way it goes. I think the only thing left to do is to thank you all very much for joining us, some of you later in the evening and it's early in the morning for some. So we're really pleased to have you join for the first international arbitration briefing of 2021. And unless Alan or Stuart want to say anything more, I think that's all from us.
Alan?
Just to say, I hope you found this an interesting debate. I think the three of us certainly found it interesting. And maybe when we have a webinar later this year, we can discuss whether we think the Privy Council got it right or wrong.
Yeah.
And I will just add two things. First of all, on the Privy Council website, we now know what the composition of the Privy Council will be hearing this case. One of the judges is Lord Leggett, with a long commercial court background, and I suspect that he will be one of the judges taking the lead in the decision. So I hope he's listening to this webinar or watches it later as well. Just in conclusion, on a logistical matter, there will be a short anonymous survey that's going to pop up in your browser when the webinar ends. We would very much appreciate your completing that to see your feedback, and I hope that you have all enjoyed this as much as we have done presenting it. Look forward to seeing you in inverted commas again.
Thank you.
Thank you.